Good morning and welcome back to our third and last day of our symposium. As we have each day, we want to acknowledge and recognize the Lenni Lenape and Wappinger peoples whose original nations comprise the lands on which Columbia University is built. The meaning of this acknowledgement was brought home forcefully in yesterday's remarkable panel with Teresa Beardall, Frank Edwards, Addie Rolnick, Lauren Van Schiffelgaard, Brett Shelton, and Lisa Kelly, who re-entitled their panel, Lessons from Indian Country on the Origins of Child Welfare and the Reimagining of Alternative Futures. I urge all of you to watch this panel if you haven't already, to understand the foundational roots of taking children that we are fighting today. As the panelists said, the Native experience is emblematic to what the child welfare system does up to and including today. We also want to take this opportunity to thank everyone again who has been involved, the support team, Michelle Ellis, our panelists, and especially the moderators for building such accessible and meaningful sessions for all of us. We know we are going to have that again today in the 4 panels that will go on over the course of the next few hours. Like yesterday, at the end of each session, there will be a short breakout room. What we encourage you to do is to take your cursor down to the bottom of the page. You will see toward the right that it says breakout rooms. The breakout rooms are a combination of rooms that you can go to talk to the particular panelists, as well as affinity rooms and geographic rooms. Based on a request yesterday, we're adding Canada because there are several of you from Canada here. So if you'd like to get together to talk, please do. When the breakout room is done, the best thing to do is to go back to the program and hit the next panel button. And that will take you to the panel that is up next. I wanted to mention that at the bottom of the Strengthen Bonds website is the keynote from Wednesday night, as well as the discussion from the Dawnland presentation in March. The movie itself, the film itself is not available on the website, but it is available on PBS Passport and also on the Upstander Project. The recordings from yesterday are currently on the Facebook page of the Columbia Journal of Race and Law. They're unedited, but they're available right now. When the edited versions, we just need to clean them up a little. When those versions are available, we will send to everyone who registered a link to where they're going to sit, along with other materials from the symposium. Okay, so I just want to say again, thank you for participating. Thank you. Even through the screen, we could feel the energy. It's not quite the same, but we hope you're able to not just learn lessons, but make connections so that we really can move this movement forward and to change the family regulation system into a system that really supports children and families every day. Last reminder, there's no wrap up at the end of the day. There's a half-hour breakout room. And when you're done, know that we're waving goodbye and saying thank you for participating. And now I'm going to turn it over to Nancy, who is going to introduce our slam poet, DeMonte Thompson, and say a few words. Thanks.
Thank you, Jane. All that's left for me to do is introduce you to our performance artist, DeMonte Thompson. DeMonte is the executive director and co-founder of Twinspire, which you can find at twinspire.org. He is also a PhD student in urban schooling at UCLA. Having been in foster care himself, he has used his experience and knowledge to author books and policy reports to improve services for foster youth around the nation. You can find more of his biography in the program. And without further ado, I'll introduce DeMonte.
Thank you so much, Jane and Nancy, for putting this on together for us to come here and theorize and make an understanding to push the needle forward. As mentioned before, much of my work is stemmed from my personal experience in care, but also my advocacy and justice work with young people in Compton, where I'm from, in Los Angeles. I'm honored to be here with you all today, and I'm sharing a piece that I wrote specifically for this convening. It's entitled Black Bags. Sometimes I look up to the sky and see all the possibilities of who I can be. A Black man born in a nation that's scared of me. A man forced to reconcile my future with Americans' insidious history. Being foster is like being lost. Trying to find your way home in a place where you don't belong, having to pay the cost for all the mistakes the system made. And every turn is wrong. The memories fade. I can't remember the trauma incurred, but I'm sure I placed it on Facebook for all my friends to observe and respond with all their family privileges. We fosters go through pilgrimages of identity crisis and maladaptive generational cycles. We are funded to empty boxes, houses that aren't prepared for our complex nature, cells without green pastures, and the streets that give us more comfort than any court-appointed teddy bear could offer. I feel we are just wards, waiting on our Emancipation Proclamation to make something of our lives, lively and mummified, scouring for meaning and connection. We're all connected to others who have also been met with resistance. Given a Black bag to pack our lives, our dreams, our tears, tearing us away from the only familiarity that we know without recognition. And still we foster moxie, rumbustious advocates for social justice and political change. We hand over our votes to the most promising, but we're bamboozled into thinking we can win justice in a system created to keep us quietly adopting new ways of thinking how we're the problem. Thanking our masters for letting us go out to march when the bells have already rang for freedom. Yet naive enough to ask for free education when they'll just teach us the version of their liberty. Broke with our Black bags. Loans with our Black bags. No Wi-Fi, but thanks for the Obama phones with our Black bags. Our Black bags are full of pain, disdain toward this system that created us, Hefty could not create more of a durable plastic to hold our worthy causes and fiery hearts. To abolish this system as we know it, we know just where to start. Check our Black bags. Foster youth, check your Black bags. Thank you.
Thank you so much, Devontae. Snaps and wow, it's really beautiful. So transition is now. I hope we keep Demonte's words in mind as we go to the next part of our program. Thank you so much. My name is Sharissa Smith, and I'm associate professor at CUNY School of Law, City University of New York School of Law. And I have the pleasure of welcoming panelists to this next segment, which is our family defense lawyering panel. And so in continuing with the themes from yesterday, it's a real honor to moderate. And I want to thank, the organizers as well as Professor Roberts for continued leadership and inspiration. So from now until 12:30, our panel is going to look at both localized case level challenges and also macro level transformation and power shifts. These panelists are going to examine family defense lawyering and the courts to ask what's required of individuals as well as, on the systemic level to really empower and resource families of color, youth, and to curb government outreach. Really quick to quote Children's Defense Fund founder Marian Wright Edelman, if you don't like the way the world is, you change it. You just do it one step at a time. And yet, right, we know paradoxically that reformist reforms don't equate with abolition and radically new ways of being. And so our panelists today are going to acknowledge those tensions between immediate response to the entrapment that families are facing and also broad transformational goals, and they'll delve into their own work on point. The format for this panel is that each panelist will take some time to summarize their particular work and the articles they've done. And then we're going to have a couple targeted questions that I'll ask of the panel. And then, the panelists will have an opportunity to talk to each other before we open it up also to audience Q&A. And I'll be keeping the comments in the chat. If folks have questions that they want to save till the Q&A portion for the audience, opening it up. And for panelists, I'll give you a nudge at maybe 10 minutes to help you keep track of your individual time. And so I encourage you to check out the bios of our esteemed panelists. But first, presenting, we'll have Jessica Lopez Espino, who has a PhD in anthropology from NYU and is a fellow in law and inequality at the American Bar Foundation. Jessica's paper is entitled Minimally Fit Parenting is Not Good Parenting, Challenging Beliefs About Parental Care in Child Welfare Cases. So we'll turn it over to Jessica.
Thank you, Sharissa. I'm going to share my screen, so bear with me 1 second. So I'm going to be talking about, and I wanted to thank the organizers for putting together this great panel and event, and also the wonderful poetry that we just heard. Really honored to have been able to hear Demonte's work this morning. So I'm going to be focusing on a subsection of the paper, which I'm calling Orchestrating Compliance and Evaluating Evidence in Child Welfare Cases. Between 2016 and 2018, I spent 18 months observing a California child welfare court and following the cases of 40 parents who participated in my study on parents' experiences in child welfare. I spent the first 6 months recruiting participants in between hearings, meeting with attorneys and social workers, and having conversations with court-appointed special advocates, secretaries, interpreters, clerks, bailiffs, to get an understanding of how they understood their work environment and the people that came through its public entrance. Court professionals often offered a kind of typification of the kinds of cases that they see and work with as advocates. One attorney asserted that most of his clients were part of, quote, the 6% of people in the population with very low IQ who use 90% of the court's resources, end quote. Being one of my first interactions with this attorney, I did not press him on the sources of this numerical information, but I understood right away that the attorney was asserting that parents in this setting are unintelligent and dependent on state resources. However, this perspective of parents as society's dejected and dependent class comes from a particular perspective. It is not fact, but rather an interpretation that is not neutral despite the matter-of-fact tone. In my work, I hope to show how law is structured to bolster the perspective of low-income communities as risk to children, and how perceptions of parents as inferior and unfit are steeped in white middle-class ideals of self-sufficiency, ableism, and individualism. These ideas are circulated by professionals with law degrees and social work degrees, stable incomes and homes whose life experience are many times very different from the low income and poor parents who find themselves coming to the child welfare court. And so as parents are trying to be evaluated as minimally fit parents to maintain or regain custody of their children, they're consistently being evaluated by court professionals as liabilities and as a drain on public resources. In my study, I focused on 40 parents, 22 of them who were in family reunification cases, meaning that their child was placed outside of the care for the duration of the 6 to 18, sometimes 24 months that they were involved in child welfare proceedings. And then 18 families who were in family maintenance proceedings, meaning that their child was in their care for the duration of court-ordered services and court hearings, but that that at any time their case could change into a family reunification case where their child was taken from them. 18 of them were Spanish dominant parents from the United States, Mexico, Guatemala, Nicaragua, El Salvador, and Honduras. 14 of them were bilingual or multilingual, and 8 of them were English dominant. The current evidence, and so current work on evidence shows that evidence in child welfare proceedings is on shaky but determined ground. Parents are often investigated on circumstantial evidence, inferences, suspicions of abuse or neglect rather than direct evidence. We also know that most of the cases in child welfare proceedings are based on allegations solely based on neglect. In California, that number is about 70% of all cases are solely based on neglect, which is, as we know, a very wide category. Social workers and attorneys tend to err on the side of caution and enroll families into court supervision despite inconclusive evidence of harm because of concerns of possible risk of harm, but also concerns that if children are harmed after a court decision to forego intervention, that this could negatively affect the legitimacy of the child welfare system as a whole. And so one of the contributions I hope to make in this field is to draw more attention to the legal standards of evidence and how they support and sustain the structure of family policing and surveillance, and make it hard for parents to challenge their involvement in the child welfare system. In California, jurisdiction can be established by proof by a preponderance of the evidence, meaning more likely true than not true. And this is used to support a finding that the minor is a person described by the Section 300 of the Welfare and Institutions Code as a dependent or ward of the state. Due to this low standard of proof in jurisdiction, it's rare for cases to be dismissed or challenged at the outset. This low standard of proof makes it difficult for parents to challenge the allegations against them, and then makes it easier for courts to continue on with assigning court-mandated services and surveillance for months as parents may seek to maintain or regain custody of their children. And while the state requires clear and convincing evidence for removal, the initial use of preponderance of the evidence allows for information concerning risks of possible risks to children to be allowed as evidence for the entire life of the case, because parties can refer back to the jurisdictional report and use that as grounds to challenge the return of children or closing of the case, depending on the information that has been accepted in that case report. In thinking about preponderance of the evidence, I'm thinking as a legal and linguistic anthropologist. We know that there's no objective perspective from nowhere, but rather that what's called true reality by particular persons is always contested, political, and informed by historical investments. It's hard to know definitively what occurs in private homes and communities related to children. And therefore, child welfare courts become an arena where ideas about what is more likely to be at risk to children can gain power and have significant effects on the lives of marginalized actors. Evaluations of evidence are subjective and dependent on the person doing the interpreting. What is more likely for one person may be different for another layperson. And I'm using this image of the pointing finger because in where I grew up in public elementary school, the kids would say, if you're pointing at someone, you have 2 fingers pointing away from you, but 3 fingers pointing back. And I'm thinking about preponderance as something that tells us more about the people doing the pointing and evaluating rather than the people being evaluated. And so legal standards of evidence in child welfare proceedings limit resistance and lead to coercive compliance. This attorney explained to their client in the child welfare proceedings before jurisdiction, quote, if you went to trial, more evidence could come in that there's a risk to the child to be with you. The more people explain about the allegations, right now they sound like rather minimal, small stuff. But if somebody came and testified at trial that actually in the full information of this is what happened, and it happened 6 times that way, it can make your case look worse, end quote. And so due to the standard of evidence, many parents and attorneys felt powerless and unable to challenge or mount testimony to deny allegations, because allegations just have to reach a standard of more likely true than not true. This leads to more attorney emphasis on compliance rather than direct challenges of the facts of a case or the need for court intervention. This emphasis on compliance and efficiency in moving cases along also positions parents as secondary to institutional goals of efficiency and expediency, as the court claims that it's moving things faster along in order for the benefit of children to have a more permanent plan. In other words, parents are told to stay in line. Parents are told to avoid speaking out and contesting allegations. They're told to complete a wide range of services that can negatively affect their ability to maintain or find employment. In other words, they felt they were set up to fail. Parents also, many times, the focus on compliance by attorneys also reinforces the stereotype that many parents had of the public pretender, where they felt that their attorneys were working more for their colleagues or for the institution rather than for developing a rigorous defense of their case. This also has negative impacts for Spanish dominant speakers, as concerns about time and pushing cases faster sometimes leads to inadequate interpretation, volunteer interpreters being asked to help. Spanish dominant speakers don't get a copy of the case report in their language, and so often they don't know the full extent of what they're submitting to. Spanish dominant speakers also are likely to report that they have had no communication in between court dates with their attorney, as many attorneys rely on court-provided interpreters to meet with their clients. And also this has an impact because they have the same amount of time as English dominant parents to meet with their attorneys, typically for 15 to 20 minutes before court dates, while many times using an interpreter prolongs the process. And so many parents need more, Spanish dominant speakers will need more time with an interpreter and the attorney than English dominant clients, but typically don't get that more time. So what should be done? I'm not suggesting that we tinker with the standards of evidence, but I think it's important to understand how the law is mobilized to reinforce broad authority and discretion to attorneys, judges, social workers, and perpetuate the social belief that such proceedings are fair and evidence-based, despite the ways in which ideological beliefs shape interpretation of what counts as evidence and what is more likely than not to pose risks. These laws are mobilized to shape the legitimacy and power of the state to continue to intervene. The spectacle of reading statutes, child removal, and distributing legal documents in the specialized legal setting where such biases can be baked into the evidence standard informs why the system is so celebrated and perceived to be fair among more conservative circles. I think this requires scholars to think critically about what the role of law should be moving forward. And so I'm looking forward to the discussion today. Thank you.
Thank you so much, Jessica. Next, we'll hear from Melody Webb Esquire, Executive Director and founder of Mothers Outreach Network, Incorporated. Melody's paper is entitled, Taking a Multifaceted Empowerment-Centered Approach to Entanglement in the Foster Care System, that focuses on building power to tackle African-American family poverty. Melody?
Thank you so much. I'll just share my screen. Bear with me for a second. I'm pleased to be here today and to share our work and have a discussion with you about it afterwards. Yesterday during panel one, a conference attendee posed the question regarding whether universal basic income can help us address the underlying problems that propel the child welfare system. My answer is yes. And I go even further and say that in combination with other strategies, it can propel the abolition of the system. I will talk about our policy work and our emerging legal advocacy program, which is informed by my past work as a parent defender. Our work centers around building parent power through political engagement to achieve economic security. Agencies and judicial officers possess wide discretion in handling allegations of child abuse and neglect. They could opt to empower parents by providing them with financial assistance, adequate housing, and other benefits, and too often they do not. That's not the mission of the institution. Instead, they choose all too often to further enmesh parents in services that they do not ask for, while they're under the supervision of mandated reporters, forcing them to do the impossible of complying with safety plans, for example, when they're struggling to keep the electricity on, or to reunify with their children when they have lost their housing, or have been placed in a family shelter upon losing their children. When a family faces eviction or otherwise requires critical emergency assistance, a caseworker has the discretion to provide them cash assistance for a month's rent rather than petition for the removal of their children. Failing this, we would hope that a presiding judge would ideally order an agency to do so when the matter has reached the courts. As background, our mission is to support Black DC mothers fighting for economic security while navigating the child welfare system. We're a lawyer-led organization, and we deploy community lawyering and interdisciplinary strategies, and we work with a wide range of organizations to facilitate collective action. We're pursuing 3 goals to disrupt the approach that the current system takes to maltreatment, child maltreatment. First, to shrink the family regulation system through transforming its funding structure and disrupt parent involvement in the system in that manner. Second, we seek to change the narrative from judging parent behavior to uplifting the dignity and agency of these predominantly Black mothers here in DC who are impacted to raise economically secure families. And third, we seek to foster power building and parent civic engagement on legislation, and to engage parents in otherwise influencing policies that impact their own lives. Our strategies currently include a vigorous policy advocacy campaign in coalition with other diverse organizations, and we have an emerging legal program, which I will describe shortly. Just for context, let's talk about the risk factor of poverty, which is critical in maltreatment cases. What does that poverty look like, for example, in Washington, DC? As background, Washington, DC has one of the largest racial wealth and income gaps in the country, and Black children comprise 82% of foster system cases, while there are only 52% of children in the city. 26% of Washington, DC's children are impoverished. Our response to this poverty as a city, as a nation, in fact, across the country is abysmal. So let's look at some figures. In 2010, the most recent year for which data can be found on the internet regarding this factor, the local agency made foster care payments in the amount of about $920 a month for non-special needs children under the age of 11. By comparison, $414 is the maximum monthly benefit to a child-only TANF household. And that number is far below 100% of the poverty level. A 2018 DC Council report actually reflects that the monthly level of income needed for basic necessities in Washington, DC for an individual is $3,000. So to emphasize the estimated level of income that 3 typical households in DC wouldn't need to pay for their basic necessities absent government programs is higher than the current minimum wage. So we have a situation of stark poverty resulting from racialized barriers to economic self-sufficiency. This has been discussed throughout the conference. Poverty is significant to all of our work for abolishing this system, as the family regulation system is a system of impoverished Black, Native, and Brown people. Scholars have found a connection between poverty and neglect-based maltreatment, structural racism, and oppression at the root of the social factors that reveal themselves as maltreatment in the eyes of the family regulation system. The pathology is in the root causes of poverty and not in the parents. Studies demonstrate compelling economic risk factors for maltreatment and the beneficial role of strengthening household financial security and making prevention possible. Just for example, I'll cite a few statistics. Increasing a family's income by $1,000 through the Earned Income Tax Credit was associated with a 3 to 4% reduction in neglect and an 8 to 10% decrease in CPS involvement among low-income single mother families. States in which families lost all TANF benefits for not working saw a 12% increase in child maltreatment victims, a 23.2% increase in neglect victims, and a 12.7% increase in foster care placements. So strengthening household economic security can reduce child abuse and neglect by improving the opportunity for parents to meet their children's basic needs, provide developmentally appropriate childcare, and reduce parental stress and depression, risk factors for child abuse and neglect. So what is our work and our solution and approach to this? 1960s era welfare rights activist Johnny Tillman turned what we currently call universal basic income a guaranteed adequate income, as did many of her contemporaries. And I'd like to just read her what she said, which is so noteworthy. Maybe we poor welfare women will really liberate women in this country. Our group is called the National Welfare Rights Organization. We put together our own welfare plan called Guaranteed Adequate Income, which would eliminate sexism from welfare. There will be no categories, men, women, children, single, married, kids, no kids, just poor people who need aid. You get paid according to need and family size, and only that would be upped as the cost of living goes up. Racism in child welfare policies and public aid, principally TANF, work to demobilize Black parents, reinforce racial hierarchy, particularly gendered assault against the citizenship of Black mothers. Public aid and family regulation come together in their oppression of Black women, as Dorothy Roberts has written about so eloquently. Borrowing the term dignified entitlement, which Dorothy Roberts has used in describing the system, universal basic income is a policy approach that we have been working on in conjunction with other organizations. As mentioned, it's called universal basic income, meaning that money would be available to everyone. It would be cash, unconditionally provided. This program or concept has been gaining steam in the form of guaranteed income programs, which are a version of universal basic income, but they are targeted. And so it's been gaining steam in recent years after interest died in the 1970s following failed attempts to pass a universal program. Because of the pandemic, racial, gender, and economic injustice exacerbated by the pandemic, philanthropists have been funding basic income pilots. And we think that this needs to be done on a widespread basis and done by public entities. There's pilot programs around the country. The idea is that they are dignified. They're seen as a dignified entitlement. There are programs in Santa Clara that are providing $1,000 to foster youth upon their aging out of the system. There are programs in Denver. There are programs in Jackson, Mississippi. These programs have been borne out the results that we all know are true, that people who are impoverished know what to do with income when they receive it, with cash income. And so there are some quotes that are widely being cited to reveal how much of an impact cash income could provide on people's lives. There are people who were cited to have said in one study, I have hope that I'm not feeling like I'm treated as a freeloader anymore. If someone needs groceries, I'm like, I can now go to the store and get it. I don't feel like a parasite anymore. So once these pilots have finished, Evaluators are producing reports that are demonstrating their efficacy. They're looking at improvements in health, nutrition, and general quality of life. This parent's sense of agency and dignity and empowerment. We are working to divert income streams of income from public sources for a pilot program with a longer term vision of a publicly funded universal, or rather guaranteed income program in Washington, D.C. Our premise is reducing poverty, which would strengthen protective factors in families who are at risk. As with other pilots, we seek through a family preservation pilot, which we've termed the Mother Up pilot, to demonstrate improvements in mental and physical health, nutrition, and general quality of life. We view this pilot as a program for the mitigation of harm on the road to a bigger transformation. And we really seek a widespread to spread this widely throughout the regulation system. And what we would do is we would start with this program for 40 women. We would provide them with an income supplement of $500 that would bring them up to the poverty line. And we would initially work with 10 participants, hoping at maximum 40. We provide them with income for a period of 3 years. In Washington, D.C., where the poverty line is $12,000 per person, the cost of living is $36,000. We think that this would be a significant improvement. It could lead to improvements and outcomes in families at risk for foster system involvement. Our work has entailed a widespread grassroots policy and legislative advocacy campaign, organizing, education, parent engagement. We've launched a campaign to sway the mayor of Washington, D.C. to support guaranteed income program. A local city council member has become involved in these efforts and supporting a guaranteed income program. Our modest ask has been that our mayor at least engage in doing what 50 mayors have done so far in exploring universal basic income. We're writing and researching legislation to make the program publicly funded. And we've facilitated what is an intersectional campaign of a range of groups, from our local statehood Green Party to children's rights groups to a wide range of others. This intersectional diverse coalition, we believe, is critical to changing narrative. And Dorothy Roberts has written about diverse groups being critical to such struggles and having radical possibilities. And we think that this is incredibly important moving forward. So we're working to complement what we see as our large systems of oppression work with work that is harm reduction oriented, a civil legal services program for CFSA regulation system involved parents. So we are working to do the following. We're working to get local parent defenders to advocate for financial assistance and benefits for their clients, encouraging them to request and the judges to order direct cash assistance, and also do things like requesting that child tax credit benefits be directed to biological parents in foster care under the new expanded program, a position that the Children's Defense Fund also supports and is seeking to get enshrined in regulations. Our program goal is to help as follows: through representation at administrative hearings, through advice and counsel at the investigation stage. Again, we are interested in a pre-petition program, screening, advice, and referral for individuals who are seeking information without taking them on for full representation. So our litigation, our legislative advocacy seeks to achieve all of these things: a right to minimum income of at least 100% of the poverty level for families that CFSA identifies for abuse and neglect allegations to meet their cost of living, a right to public assistance and housing to support family reunification, The irony is not lost on any of us. I'm sure that just as parents are having the rug pulled from underneath them and losing many of their benefits, they're being asked to demonstrate that they're worthy of being reunified with their children. We'd like to repurpose child welfare funding sources for direct cash transfer programs, such as the pilot I described. And we'd like to make use of TANF, the block grant program, to pay for direct cash transfers as well. Our understanding and preliminary research is that there are programs around the country that are using the TANF program to pay for foster services. And we'd like to end the use of TANF payments for foster services. So finally, we must use creative strategies in the courtroom and in our policy advocacy to divert funds from the foster system to parents who are in need, who are very much in need, if they are to preserve their families, if they are to reunify their families. These are strategies that we must pursue. As I mentioned before, the child tax credit expansion is currently not available to be claimed by parents with whom the child, after the child is removed from their home. And we need to advocate in coalition for systemic change in that regard, but also in our individual cases. TANF funds are used for a wide variety of purposes rather than assistance to indigent families. And we must reclaim those funds and try to have them directed to the families in the foster system. And additionally, in the past, reasonable and occasional costs such as baseball tickets have been reimbursable under Title IV e-foster care as part of a maintenance payment. Well, they've been deemed reimbursable for staff supervising children. When children are in the foster system, they should be reimbursable to parents once they become system involved. These are all potential sources of funding that we should explore in disrupting the child welfare system, the child regulation system. Thank you, and I look forward to just further discussion about these ideas and others.
So much, Melody. Next, we'll hear from Carla LaRoche, Assistant Clinical Professor directing the new Civil Rights and Racial Justice Clinic at the Washington and Lee School of Law. And Carla's paper is entitled "The New Jim and Jane Crow Intersect: Defending the Parental Rights of Mothers During Incarceration."
Thank you. I'm having weird internet issues, and so if my internet goes down, you'll still be able to hear me on my phone. I just forgot to unmute my phone. Thank you, Teresa, for the introduction, and thank you to my fellow panelists for diving deep into each of your projects and your research, and continuing the insightful discussions that we've been having, and I've been observing the past 2 days. Because the whole discussion, whole symposium is on the family regulation system, and my fellow panelists have gone into the system itself, I will not go into that. My focus will be on Parents Council and their attempts to defend the parental rights of mothers who are incarcerated. So my conclusion up front, for mothers who are incarcerated, the challenges to their Parents Council, their defense council, those who represent them in this system are so many and so difficult to avoid that it ultimately means that they lose their parental rights. The system as a whole doesn't really address the best interest of the child, but when the mothers are incarcerated and the council need to navigate two intersecting systems, that goes out the window completely. That standard goes out the window completely. The termination of parental rights for mothers who are incarcerated becomes even more difficult because of the idea of the system believing that they are taking children away from bad or dangerous mothers, even when their criminal offenses, alleged offenses, have nothing to do with their parenting. It is essentially reinforcing the bias and harmful outcomes to two systems, the criminal legal system and the family regulation system. My why. My career has focused on the intersection of these two systems, the family law system and mass incarceration, and the way that these women, mothers, are trapped in these systems. And then the consequences to them and their families as a result. My Gender and Family Justice Clinic, previously I worked at FSU, Florida State College of Law, and my students would go into prisons and jails to teach family law workshops to the women who are incarcerated there and take on direct representation of women, or no, parents with family criminal justice involvement, whether that is an arrest to incarceration or reentry. And in those conversations, in these representations, in these workshops, the most well-attended was the one on the family regulation system and the rights of and responsibilities of the parties, whether that's the mothers themselves or the systems or their attorneys. And so the idea, looking at the stats, it becomes a confirmation bias. The assumption is that there's a high rate of termination of parental rights for mothers who are incarcerated because they don't care about their mothers. But in those rooms, in those classrooms, and in those discussions, there were tons of mothers who wanted to figure out how to protect their parental rights even while incarcerated. So what is going on? The concept New Jim Crow, which many of you have likely heard of, was coined by the legal scholar and law professor Michelle Alexander to explain how mass incarceration has become, for Black people, especially in America, another form of systemic racism born out of slavery and Jim Crow. And when we discuss, when the media, when leaders discuss the prison industrial complex and mass incarceration, they normally focus on men. But that misses a critical part of this problem. And that is this. The rate of incarceration for women has increased by over 700 to 800% in the last 40 years. It has increased so much so that it has surpassed by 2 the rate of incarceration for men. The majority of women who are incarcerated are in jails. They are awaiting trial. 60% are still awaiting trial, which, if you think about it, it's really because of the money bail system and the inability to collect the funds to then pay for the bail to get out. When we look deeper, oh, and I will also recognize, I put an asterisk there to recognize that these, this data does not address gender nonconforming individuals and non-binary individuals. So there's more to this data that needs to be looked at, but this is a starting point for data that many people don't recognize exist. A quick note on what we already know from both systems. Black, Latina, and Native American women have a higher rate of incarceration than white women, disproportional to their total population. Where does the new Jim Crow come into this? As I mentioned, the workshops for discussions of the family regulation system and the law were well attended. 80% of women in jails and 60% of women in prisons are mothers with minor children. That leads to 1 in 12 children across the nation having experienced parental incarceration at some point during their childhood. When fathers are incarcerated, more than likely they will live with their mothers. With their mothers. When mothers are incarcerated, they will reside with third parties, whether that's a family member or the family regulation system is where they're pushed into. Before I go into my main argument, I wanted to present 2 caveats. There is a robust and increasing discussion of right to counsel and right to attorneys in the criminal legal system and how that system is broken. Here, I want to do the same thing and identify the systemic defects in the state right to counsel. I am doing that while also recognizing the work as a parent's counsel, a parent's defense counsel, is hard. My focus isn't on the passion of those doing the work. My focus is on how that passion is limited by the challenges they must face because their clients are incarcerated. My other caveat is there is no constitutional right to counsel for parents. Whether one has a right to counsel in the family regulation system depends on each state by state decision, and it differs by state in eligibility and in timing. So for example, in Florida, a parent has a categorical right to counsel in all stages when the state is involved. A judge in Minnesota or Nevada has the option to appoint counsel even when the goal is termination. So it depends on which state you are when you get a right to counsel, and if you get a right to counsel after seeking it. So what are the challenges? All of the challenges that parents' defense counsel have when their clients are out are magnified when their clients are in. In my paper, I go into each of these buckets and delve deeper into each one, but because of time, I will not do that. I want to highlight that parents' counsel, the state agencies and social workers, and the courts themselves all have implicit and explicit bias. The marginalization of mothers who are incarcerated as bad mothers. There's already an assumption that mothers are bad because their children are in the system. Add to that they're also in another system, in the criminal legal system. So they're punished twice because of their criminal offense, which again might have nothing to do with their parenting. Access issues are even harder for parents' counsel for their clients. Calls, even legal calls in certain jails, cost money. There is no free access to calls or for video conferences. The ability to establish a parent-child relationship is even more difficult. We often tell our clients to send postcards. However, the stamps cost money, and if their family members don't have the money to put funds on their books, the access to even sending stamps gets harder. Timing in terms of laws and policies, with the federal laws requiring the 15 to 22 months if a sentence is longer than that, but also the lack of support within and once released for reentry. The higher rates of unemployment for mothers, especially Black mothers, with histories of criminal histories. Ultimately, that results in termination of the mother's parental rights because the mothers are silenced through their counsel's inability to address all of these systemic issues. The child, again, is harmed because the best interest of the child may be to stay with and have an intact relationship with their mothers. But ultimately, the court will terminate the parental rights of the mothers who are incarcerated. I put reforms in question in quotations because as we've been discussing throughout this symposium, the reforms aren't good enough right now. There were organizations like Still She Rises in Oklahoma, which used to be the state with the highest rate of incarceration of women in the nation, which is now second. They focus on a holistic defense dedicated exclusively to mothers who are incarcerated and involved in the criminal system and the civil system. But my ultimate recommendation is that we just simply stop incarcerating we stop incarcerating people and we stop criminalizing mothers in poverty, which goes into both. The incarceration ratios and offenses that mothers who are incarcerated face are more societal poverty related crimes and that is also what pushes the family regulation system. So stronger safety nets, ideas like what Melody was just referring to, and the issues that Jessica referred to in her presentation need to be addressed, but I recognize that we must start somewhere. With that, I invite your thoughts and questions on the intersection between mass incarceration and the family regulation system. These are an intersection. This is an intersection that traps mothers, and we should be talking more about it because they are more related than it seems, than you might realize. And the myth of the support that appointed counsel have for mothers who are incarcerated needs to also be busted because there's so many challenges above and beyond what the system already pushes on them. So thank you.
Thank you so much, Carla, and thank you to all the panelists for your presentations. You all touched upon a lot of the themes that I had for individual questions, which is great. So I'll just kind of pose one question, which actually ties into one of the audience Q&A for Jessica, but I'll pose it also to the broader group. The question was about, for example, for Jessica, for your work, why can't it be both and perhaps that we, elevate the evidentiary standards, right? We tinker with that in family court ASAP, and yet also work on the broader goals, right? At the same time, I know you had a slide that said, you're not necessarily suggesting that we change the evidentiary standards. And then, opening it up to others as well, what are your thoughts about just like at least tinkering with those vital standards as much as possible? All of your work kind of touched on this idea of the best interest of the child, right? There's a lot of reason to change that completely, do away with it. But what does it mean to expend energy in that kind of legal reform when there's so much other reform to be had, and also some macro level work that you were all doing too? So turn over Jessica first.
Absolutely, that's a wonderful question, and I've been thinking about this a lot. And so I think that's exactly it about the energy expanded. So I think to change the standards of evidence and to mobilize to change statutes takes a lot of time, a lot of energy. And some folks can get started on that, or probably started on that, and I'm not sure of that effort. But the point is that we're trying to tinker and adjust this in the meantime. It can divert energy from completely restructuring and reimagining what we envision should be the alternative to the child welfare system. So I think, again, this links back to what Dorothy Roberts said in the keynote, is that the tinkering can divert energy and sometimes reify the power of the state to intervene and continue to wreak havoc on racialized and minoritized communities. And so even if standards of evidence are adjusted, I think we still need to question the major point of that 80% of families that are involved in the child welfare system in the first place their main allegation is neglect, and that this neglect is highly correlated with issues of poverty. And so I think more energy towards what Melody was proposing in her presentation gets to maybe the image of the tree, of the root of the problem, rather than trying to shape the branches afterwards.
If anyone else has thoughts on it, please jump in about this particular question.
Yeah, I won't. No, go right ahead. You go.
I mean, for my piece about the raising of the legal standard, as Jessica said, raising it would tinker with the system that, if we look holistically, if we keep tinkering, we might decrease the amount by a little decrease the trauma by a little that parents and families endure, but it must go deeper than that. I think about the graphic that Jessica with the hand piece. I really like that idea because that objective standard is really subjective to what your experiences experiences are. So if we raise the standard but don't really get at the pointing back at you piece, then we're still not there yet.
Yeah, and I was just going to talk about the, the best interest of the child, just kind of ensuring that, giving more than sort of lip service to it, and actually, making sure that, there's actually sort of, financial support around keeping children, with their parents, and, really being aggressive and pushing, judges to, to sort of put resources behind this best interest of the child's being in care with one's own family, or remaining and reunifying with one's family. So I think that, that's one that, we can sort of put pressure on, the courts to pull all of their resources, put resources behind fulfilling the best interests of the child by keeping them with their families.
Carla, let me just say thank you for engaging with my idea about the pointing finger. And I think that brings me back to the point of like, okay, we changed the standards of evidence points, but we're not changing the judges, the attorneys, the people who are inhabiting and providing funding for these institutions. So, I mean, we could tinker with the standards of evidence, but then you have the actual folks and their worldview that shapes how they interpret evidence. And then also, the case law and the previous history, right? So like judges are also limited by how they can rule on something if it has been established that certain things have been seen as already more likely true than not true, or more likely at risk than not true. Even if they individually have wider ideas of what families should look like, they're still limited to pre-existing decisions also. So I think these are some of the complications with just tinkering, for example, with standards of evidence.
Absolutely. And one other question I'll pose to the panel before we get to another audience question in the chat. Kind of along those lines of what you're saying, Jessica, I guess this question is more inward looking for the legal profession or for the judiciary. If you did have, right, a magic wand and you were focusing particularly on our profession, whether it's ethical rules or whether it's, family court judges in that respect, what kind of, shift would you really require right there of our profession and of the judiciary as well? Like what can we do ASAP to shift?
One strong piece is diversify the bench, right? Like the lack of diversity across the nation, whether that's state or federal, trial courts or appellate courts, the assumptions that because your parents didn't do it or you as a parent don't do it, therefore this parent doing it is incorrect. But if we have more diversity of thought in the judiciary and also attorneys generally, who then become judges, if we have more diversity of thought, if we have more people who have been directly impacted in these positions of decision-making positions, then perhaps we can have that change and movement more holistically so that the precedent does recognize the problems that we've all been addressing.
Absolutely. Anyone else?
I agree with what Carla said. I mean, that would get at the issue of, what's the cultural bias that's baked in. I think Jessica mentioned this, that you see that cultural bias so therefore, even in our own defense counsel, where they are confusing, signs of distress themselves with neglect, and perhaps that impacts the defense attorney's ability to fight as zealously for their client as they should. I've actually sort of encountered situations where, I was told that I was fighting too zealously for my client. So in terms of professional ethics, I think there could be some work done around, some of our defense counsel, being more familiar with cultural, kind of norms, and also being familiar with, just sort of being more exposed, and working on rooting out bias in the way that, they look at clients, but diversifying the counsel, and also diversifying, the judiciary would, I think, get at some of these issues.
And I like to think slightly radically, slightly, not necessarily something that could be done. But if we said it's magic wand, right, that means that we're allowed to think very expansively. And so I think that I would like to see a change where all of this labor, specialized expertise, attorneys, are working towards helping and supporting families, not necessarily through the child welfare system. Maybe we don't hear the, maybe my expertise on the California dependency court system becomes irrelevant because it no longer exists, because instead we're funneling resources and our expertise into what will come after, into community mutual aid situations, into the funding programs that Melody has described, into maybe we're not dealing with prisons anymore because we've decided that this is not the best way to reform behavior and to provide support for children in our communities. And so I think that the magic wand would be the goals, not of abolition as in get rid of something and then it disappears. That's actually not the point of abolition, right? But this is to get rid of systems, to replace them with things that actually serve the community in a holistic way. So I know that's not going to happen one day to the next, but I think that this large gathering, this conference, the think work that we're doing is towards that direction.
Yeah, very much agreed. Thank you so much. And in one of the audience comments was also maybe jury trials for termination proceedings in terms of like shining light right on some of the court processes as well. And also would love to remind folks that later on in this conference, we also have Judge Ernestine Gray from New Orleans, who's a great example of, something that the bench can really do to reduce the numbers in the system. Do panelists have any questions or comments for each other?
Teresa, can I push back on the jury trial piece? Because in the criminal legal system, the assumption is if a prosecutor is claiming this person committed a crime, then really the burden goes on to the accused to prove that they didn't, as opposed to it's always on the prosecution. And so, as I believe Tariq yesterday had mentioned, if we're going to compare the systems, then the state impose involvement in these trials and proceedings, let's call them prosecutors, right? And so then I worry about the assumption that, well, if the prosecutor in this family regulation system thinks that a parent is not acting properly, and again, I wouldn't do that, then that person's right to terminate it because they're not being good parents. And it goes back to what Melody and Jessica were mentioning in their papers about the good parent as opposed to parenting standard. And then Melody with really looking at poverty. So the jury of the peers doesn't work in the criminal legal system. We have centuries of that confirmation. So it might be beneficial just to highlight, as the person might have said, the public piece. But in the long run, there needs to be wider discussions about the family regulation system and its issues.
Agreed. Juries are very fraught, to say the least, jury of your peers and all the judgments that comes within the cultural tropes too. Do panelists want to ask one another questions? I know. Don't have to.
I just had a comment, Carla, that on the completing services. So when I observe parents cases who were incarcerated, they usually what happened on the court side was that parents were said, okay, in order to regain custody of their child, you have to do all these services. And full knowing, the judges and the attorneys knowing well that these services were not available to people who were incarcerated, then they just waited 6 months for the time to be up, the services weren't done, and then terminate parental rights. So I wanted to hear more about if that was the case, or the places that you observed, and kind of what possible ways could parents actually maintain custody of their children through incarceration. If there's a super lawyer out, like, are there strategies and there's a super lawyer out there that can actually overcome these huge barriers?
So, yeah, that's part of the discussion that I have in the paper that I just didn't have time to go into. What's interesting is that Florida had, in 2018, changed its statute requiring state agencies to do more and be more proactive for parents who are incarcerated and their services. But when we were going into the workshops in the prisons and jails, they kept referring to the 6 months after their release to, like, really get themselves together. I'm like, 6 months after you're released? No, you should be able to get the visits and all that stuff once you're released. And then I realized in talking to other parents' counsel that there was just a built-in 6 months. Like, they accept that the services will not be provided in the prisons and jails. And so they will extend it, which is good to a certain extent so that their parental rights aren't terminated while they're in, but that would mean that they're not getting the services that they said is important and the reason why they terminate, like, they're in the system in the first place. Parents Council have suggested, like, if the service is needed, then why are we not getting it immediately? Or if you can't provide it, then take it off of the case plan, right? Like, there can't be this, like, the burden's on you to figure out the service while you're incarcerated, knowing, as you said, that it's not available. But then saying once you're out, you can do it, you can complete these services that we said was so important that they were necessary. So there has been some pushback against adding these just plain, like, normal template services when they know they're not accessible by Parents Council, at least in some regions of Florida. Others, they know that the judges would laugh at them, and so they simply accept that 6 month gap. And 6 months is not that long for someone to stabilize themselves, find a job, find housing, and then be able to start seeing their children.
Right. And then they also say, well, you haven't seen your child in 6 months, so you no longer have a relationship with your child. It's another argument I've heard.
Well, we'll pivot a little bit and get to a couple more of questions from the audience in the time that we have. And some of them tie together very nicely for all panelists, and some are particularly focused. One has to do with this idea of where do certain needs fall in terms of mental health and substance abuse treatment, whether in advocacy you're doing now to resource part of the system or to to shift and recreate something, and also for Melody in terms of UBI and in terms of shifting resources. What about mental health and substance abuse treatment? Who's involved? What kind of aspect of funding does that look like in your view?
Can I say quickly that the rate of trauma for women who are incarcerated is much higher than women who are out, and much higher than the general public, much higher than men who are incarcerated. So it's a really important question about the access to trauma resources, mental health resources, and substance disorder services, which are poor, all of the above, poor in jails and prisons.
Yeah, so I mean, ideally, there'd be some entitlement and access to these services that, would be opened up before, as when an investigation ensues, that early on in the process. And again, I'm conscious of our desire not to strengthen, the current system, but in our focus and our wish to create a strong pre-petition legal services program, our focus is on pushing the system to identify and provide access to, to services, access to cash as early as possible to alleviate, conditions that lead to deeper involvement. So, certainly, we have in DC a system of sort of service providers to whom families are diverted as a way to prevent them from, sort of deepening their involvement with the system. But, they're limited by the availability of resources. And so, definitely this is an essential part of keeping families out of the system. We advocate very much, heavily on, increased funding for human needs programs, which reach, the parents who often end up entangled in the foster system. So I would advocate, and this is what we're trying to do, researching as much as possible where those funding streams are, for example, that are going, TANF funding that's being diverted to foster payments. I mean, we need to capture those streams and direct those funds to parents who are in need of them, and, pull them out of the foster system.
I think that there's a lot of, absolutely, there's like a lot of high needs in terms of what people need in terms of services. I just think that there's ways to get those services to people before intervention in the child welfare system. And I think that's why it's really great to hear about Melody Webb's work, trying to get people even legal representation, legal counsel before that they have an involvement, before and access to these resources before they have a case. And the problem is many of the parents that I worked with said, we sought out the social workers, we wanted services, and we were told to get the services, they had to open a case for us. If we wanted to get the service quickly and accessible, that case had to be opened against us. The problem is that opening a case has this coercive, scary part of like, well, your child could be taken away from you, or will be taken away from you, and then maybe you'll get them back. But if we actually provided parents with the services before they had to arrive at the child welfare court, then I think that would be a much better situation. Are there high needs? Yes. And I think there's other ways of meeting those needs.
Definitely. A couple of these questions tie nicely together in terms of the idea of engagement. I know a lot of government agencies, right, do, parent engagement, youth engagement with like, a lot of the apparatus of the system, but also there's some great questions about, ways that, for example, caregivers and youth can actually like work on appointing people to the bench and bar that are more representative, right? And also a question about how do we zealously advocate in the courts, but also inspire in those who are representing a different vision, like a broader vision, even as day to day we're talking about this, horrific reality of whatever hearing is next or whatever issue is next.
Angela Burton and I were having a discussion just to chat about this and how do parents and children directly impacted also get their thoughts about the judiciary out. And I've actually been thinking about this more generally after reviewing a judicial candidate's evaluation from a local women's bar and how it was racist and sexist. And then I was thinking like, wait, why don't we create our own evaluation? So like the ABA, the American Bar Association, does a judicial candidate evaluation. Local bars do it at states for state and federal candidate positions. And so I don't know if there's any organization doing this work now, and if they are elevating it for directly impacted parents and children to do their own judicial evaluation, to call out those who aren't following the broader abolition movement that we're trying to build, and those who are.
Yeah, I think I just would be cautious of the thing we were also seeing in the diversity and inclusion movement in higher education, right? That just because we have someone who looks brown or looks Black or is Indigenous on the bench doesn't necessarily that they mean to have the values of the community members, or that they defer to challenge ideas about white supremacy and whiteness as better or as safer, or and so I think it's important to try to diversify the bench, but it's diversify the ideas that are on the bench, and to not really naturalize our preconceptions and things that are very normal in the United States to normal but problematic to assume that someone's the way that they look, the color that their skin, the way that they speak their language has a direct correlation with their ideas, and how liberal or non-liberal or flexible they might be. So I think it's a good call. I just think it moving towards that direction involves significant caution.
Yeah, and I want to sort of piggyback on that and talk about, sort of the classism and elitism and just the hierarchical nature of, sort of, the judiciary or the court system, very patriarchal, demeaning, put parents in these positions where they're, sort of supplicants. It sort of, further kind of subjugates parents. And I think there are just all these sort of things, dynamics built into this process. That, I think Vicki Lenz has written about this, about the nature of the court process and how it, really disempowers parents. And so, I'd, of course, like all of us, rather have them not be in court at all and not interacting with judges at all in such personal spheres of their lives. And, so I think it's a really important job for defense, counsel to, to bolster and really, be supportive of their clients. And Jessica, you talked about, this sort of, questioning, really interrogating as defense counsel, like, whether our interests are aligned in the way with our clients and how we come across in, sort of interacting really closely and palling around with, what are essentially the prosecutors who are, disrupting their families' lives.
100%. In the few minutes that we have left, I would love to encourage folks to come to the breakout rooms for each panelist and their particular paper so we can keep this conversation going. One other question I would love to bring up, and maybe this is more to continue in your breakout session for Melody, but someone was pointing out a lot of advocacy that's been done that is great about UBI, but also somewhat of a tension with issues of intimate partner violence. So, for example, if we don't tie, income to a mother's work or, a caregiver, another caregiver, what does this mean for scenarios where there's a lot of abuse or disparity within a family system? And, what are your thoughts on that? So if we carry over till past 12:30, perhaps it'll be for your breakout, Melody.
Okay. So the question is, I'm sorry, you can just kind of recast a little bit.
It's just more about, your thoughts about those kind of considerations. If we don't tie any kind of income to a particular caregiver's work, what does that mean for access to that universal income to another person in that, family who may have more power in that scenario? Or
Right.
I think it's about more tying it to an individual particular work, if I'm understanding that question correctly.
Right. So, under this whole, universal basic income scheme, you would, have income that would be accorded to individuals and, to children. So in that sense, there's the ability to, to sort of like ensure that each individual can meet their basic needs. There are these questions of who sort of has custody of the child and who can claim, the child and their benefit. And I expect this is an issue that is, kind of arisen with the child tax credit, the sort of claiming issues. And again, there are guidelines that have been issued around that, and the Children's Defense Fund has put out, sort of a statement, a sort of position paper, advocating for different ways to address that issue. So I think we do need to keep thinking about how to deal with that.
Thank you so much. And there's a quick question about if Melody or someone else can repeat the name of the person who's done writings on the court process that you keep mentioning. I don't know if it was
Yeah,
Vicky
that's
Lenz.
Vicky Lenz.
Okay. She's written a number of publications about that. So I would just love to thank all the panelists, and as I understand, the breakout rooms are going to start any minute, and we want to keep this conversation going, but just really thank you all for your efforts and your great work. And I'll always, the articles are going to be published in the next issue.